Good morning. My name is Victoria. I'm one of the estate planning attorneys with the Copenbarger law firm. We are going to be talking about quite a bit of information in this webinar. So I always encourage anyone who attends one of our education events to take notes, and especially take notes on questions that you have. The reason in particular for that is that for anyone who attends or watches one of our videos or education events, you are entitled then to a free estate planning consultation. So I recommend, again, not only that you take notes, but that you then take advantage of that consultation that is provided. So as I mentioned, we do go through quite a bit of information. And so if you do have questions, feel free to put them in the chat or reach out to us directly. We'll answer as many as we can throughout the webinar, but if we can't get to yours specifically, again, that's where you can take advantage of the free consultation. Now, for those of you who are familiar with Copenbarger, some of this information may be a little bit redundant. However, it is important to hear it a few times to make sure that you really are ensuring that you are properly protected. For those of you who are just starting your estate planning journey, this will be a great crash course in why you need an estate plan, but also how to ensure that you don't end up in an avoidable disaster, or that your family doesn't end up in an avoidable disaster after you are gone. So especially for those of you who don't know us yet, but even for those who haven't maybe been to see us in a little while, I want to give you a little overview into who we are. So first and foremost, we have one of the largest estate planning firms, if not the largest, in the state of California. That is not only because of the number of attorneys that we have, it is also because of the number of departments that we have. So today's going to focus a lot on the estate planning side of things, the setting up a plan to ensure that if you become incapacitated, you're protected, and to make sure that after you pass away, your wishes are carried out. But that goes then hand in hand with our estate administration department. All of us, unfortunately, at some point or another, are going to pass away. And somebody, when we're gone, is going to need to make sure that our estate is administered. But there are a lot of steps that come with administering an estate. And so we have a department that is there with our attorneys, our paralegals, and our legal assistants to walk alongside whoever is left with that responsibility to ensure that anything that needs to be done can be done properly. And a lot of times that we can actually do it for that person, rather than them having to shoulder the entire burden on their own. We also have a business and tax department. So if you have rental properties, a business, you have tax questions, we are again able to address those in-house. Now, a lot of what we talk about today is avoiding court. We want to ensure that anyone who can avoid court does. However, we know that court, unfortunately, can be an inevitability, especially if you have a family that's a little bit more complicated and maybe won't just act according to the wishes you have. So we do have our estate litigation attorney so that if something needs to go into court, we are still able to take care of you or the family. But I mentioned in the estate administration department, the paralegals and legal assistants, and the reality is, as attorneys, we could not serve as many clients as we do in the timely manner that we do without our amazing staff. So our staff is absolutely the reason that we are able to, again, serve as many people as we are, as effectively as we are. We also have offices all over the state. So if you are looking for one that is an in-person appointment, odds are we have a location in your area. If your family needs to come and meet with us in person, there's again odds that we have the ability to do that. But we can also do things over Zoom and phone. So if you're not comfortable coming in person, if it's not as convenient to come in person, we are still extremely accessible. Start of this new year. Shockingly, we're already, halfway through January as we're doing this webinar. But it is a great time then to ensure, as you're starting this new year, that you're going into it organized, protected, and that you have this to-do list item that for many of our clients has sat there for years and years and years, checked off before too much of the year has gone by. One of the things that we talk about is pre-planning. Those who pre-plan and set up things ahead of time and then maximize the options available put themselves and their families in a much better position than those that unfortunately either wait until we're in a crisis or they wait until there's no options outside of court or things that could have been avoided. So that is what today is going to focus on, is ensuring that you are in the pre-planning category as much as is possible. So, first and foremost, if you do not have an estate plan, absolutely pay attention to this section. But if you do already have an estate plan, it is also important to ensure that these are documents that you have kept up to date and that they are still valid. So, when we're talking about estate planning, we're talking about a comprehensive set of documents. It is not a one stop shop where one document is going to do every single thing that you need. You actually end up needing often four or more documents in place to ensure that you are properly protected. The reason for that is, again, they all do something a little bit different. So, first and foremost, if you are over 18 years old, you need an advanced healthcare directive. You also need one that was done after 2004. So, if you do not have a healthcare directive, you need one. And if you had one done before 2004, you need to come and see us and have it updated. The reason for that 2004 date is that any of them done before that, again, became invalid. So they are not effective today if you were to need them. The healthcare directive is there to ensure that if you can no longer communicate with your doctor, that you have given somebody else the authority to do that for you. Nobody has an automatic right to make medical decisions for you. So if you are unable to give verbal authority, it needs to be in writing that your spouse could act for you, your children, your parents, your friend, whoever it is, they need some kind of authority. Again, whether it's verbal or written. This is also a document that allows you to make some of your decisions ahead of time. So, one of the things, unfortunately, that is a reality when this healthcare directive is needed is you are in a vulnerable state. And it also often means then that whoever is in charge of making your decisions, they have an additional stress and emotional strain put on them, whether we like that or not. With that being said, with a Copenbarger healthcare directive, we go through and have you answer ahead of time some of the questions that cause a lot of guilt and question and stress when the time comes to make them. These include organ donation and life support. I can speak from personal experience that when my grandma was at the end of her life, one of the best gifts that she could have done and left us is in her healthcare directive. It was very clear if she did not have any hope of recovering, she did not want to be on life support. So when that inevitable question came from the doctor of, well, she's not going to recover, do you want to put her on life support? We did not have to think. All we had to do is say, carry out her wishes. So not only did that mean that she had the dignity and control, even when she could no longer communicate it, it also meant that we did not have to question what does she want or have that extra weight and stress. So in an already stressful and emotional time, it removed just that little bit extra that otherwise would have been there. So again, now is the time to come and either get yours put in place or to ensure that you have it updated. The other document that you need if you are over 18 is a durable or financial power of attorney. This is again acting in a time when you are no longer in a position to make your own financial decisions. That can be temporarily because you're recovering from a procedure or permanently because you have something like dementia or Alzheimer's. This is again a document where you're giving somebody authority in writing to act on your behalf, but this is for the financial side of things. This is who then has authority to pay your bills and keep your lights on. Make sure if you need advanced care like a nursing home, assisted living, that you are able to pay those and sign contracts to put you in them. This is where, again, somebody is able to keep your financial life running so that there's no stress or red tape that keeps that from being able to happen. But it is absolutely important that not only do you have one, you also have one that was done in the last 5 years. Banks are absolutely cracking down on financial fraud and elder abuse, which is a great thing. But as a result, they are not in general accepting these documents if they're older than 5 years old. They're assuming if you haven't had it updated, the person shouldn't have authority anymore. Now, again, that can be frustrating. We appreciate why they're doing it, but the ramification is you need to make sure that this is updated every 5 years at this point. If you don't have one yet, come and see us. And again, if you have one, but you're either not sure if it's current or you know it is not current, come and use that free consultation that this webinar entitles you to. Now, especially for those of you who have neither of these in place, you've never created them or they're invalid at this point, The biggest risk you are at beyond not being able to be taken care of is that at that point, whoever is wanting to take care of you needs to go to court to ask for that permission if you are in a position where you can no longer grant it. So let's use this scenario where, unfortunately, you have very advanced dementia and your child needs to still pay your bills, talk to your doctors, keep your life running. But at every step, your child is told you don't have authority. The next step that they have to take is to come to an attorney. The attorney has to file something in court, and the court then has to appoint who is going to take care of you and who is going to take care of the money. Now, in some cases, that is very cut and dry, but in other cases, because they have the control of who is going to serve, it is then not the person you would have actually wanted. So, again, this is where pre planning allows you to have control, even if you can't communicate anymore. Now, the next question that we get is, do I need a will or do I need a trust? So, for those of you who do not own property or you have less than $184,000, a will is likely then appropriate for you. If you are the parent of a minor child or multiple minor children, you need a will regardless of those other two. But again, the only people who are properly protected with a will are those with no property and then who have less than $184,000. If you do own property or you have more than that $184,000 and you only have a will when you pass away, again, unfortunately, then we're looking at court as an issue. The reason for that is the court has said if you don't fall under those parameters where a will was proper to protect your estate, when you pass away, your estate has to go into court, and that is in the form of probate court. That is because they have said your will did not answer enough questions that needs to be answered. So they're going to answer, do you owe any money? So mortgages, car payments, loans of any kind. Does that need to be paid back? Does anyone owe you money? That's less common, but in some cases, somebody did owe you money. Should that be paid into the estate? Who actually gets to be in charge of settling all of this, serving as your what's called executor? And then ultimately, where does the money go? Who does it actually get to go to? All of that is to say the court has a lot of control at that point. Now, they also get to approve or deny what your will actually said. So if there's any question as far as should your will be upheld, the court ultimately is the one that then gets to determine that as well. All of that, again, is to say that the control is no longer in your hands or your family's hands. It is very much in the court's hands. The other issue with that is it then takes an astronomically long time to settle anything, even in the easiest of cases. Even in the simple probates, they can take up to a year dealing with court. But on average, we actually see probates last anywhere from 2 to 5 years. And the reason is it's all on a court calendar. So if the court doesn't have a hearing for you or another court date for 6 months or a year, you're out of luck. You're waiting that 6 months or year. So again, the control is not with the family. It is 100% then with the court. One of the biggest issues, though, to emphasize is the cost of probate. So probate costs anywhere from 5 to 7% of the gross estate. What that means is if you owned a home and it was worth $1 million when you passed away, but your equity was only $100,000, the court does not care. The percentage will be put on the entire million. So you can imagine then how quickly probate depletes an estate because you have a loan to pay off, you now have this percentage and these probate fees to pay, and the estate gets lower and lower and lower until eventually there's hopefully something to still be distributed to beneficiaries. But it is an absolutely avoidable scenario. And so that is what we absolutely focus on here at Copenbarger is, again, how to avoid the nightmare that is court. And that is often done in the form of a living trust. So a trust is there to essentially answer all of those questions the court said your will did not. It says who you were, who gets to manage if you no longer can, what happens to the estate, who gets it, when they get it, how they get it. All of these questions are outlined in your trust that you set up ahead of time. This also, if you can't tell yet, allows you, even after you're gone, to have the control of where your things go. And again, not only who do they go to, but how and when do they go to those people or entities. So, a huge benefit of the trust is that it does avoid probate. Another huge component to it is that it protects your privacy. When something goes into court, in most circumstances, that becomes a matter of public record and public information, which means your financials, your family, those things become part of a public record. With a trust, the only person that needs to see your trust outside of your attorney is you. So while you're alive, you don't have to show anybody that trust. And after you pass away, the only people that get to see that information are those that are entitled to it and included in the trust. Your trust also allows for more tax planning than you would have without one. Unfortunately, whether we like it or not, there are a slew of taxes that affect us all in one way or another. And one of the things at Copenbarger we very much seek to avoid is unnecessary taxes that could have been avoided. We will always advocate pay your taxes that are legally required. But if it is something that is legally avoidable, you shouldn't then be paying extra. And that is, again, something that your trust is able to go beyond and then protect against. So, another big piece, and I keep saying it, is we want to ensure that your wishes are carried out. But there is one big caveat when you have a trust that needs to be accounted for, and that is that a trust only protects what it owns. What that means is when you come and meet with one of us and one of our attorneys, and we set up your trust, we're going to talk about what assets need to be in the name of your trust. The reason that is so important is that if you do not have the correct assets protected in the title of the trust, they can still be subject to probate after you pass away. So, for those of you who are wondering what those assets are, generally speaking, it is your real property. So, any assets that are pieces of property that you have will need to be in this trust. Checking accounts, savings accounts, and non retirement investment accounts. Those are assets that, generally speaking, we recommend be in the trust to ensure that after you pass, they still are not subject to probate. But we do understand that things happen. Sometimes you forget, sometimes life gets in the way, sometimes it's been 20 years since you've seen us and you've acquired a new asset and don't remember what was discussed 20 years ago. So, what we have done with our trusts is we have also created a safety net in the form of a pour over will. What this will is saying is that if you have left an asset out of the trust that should have been titled in it and you pass away, this document tells the court they don't get to put it through a full probate. They need to give it back to your trust and have it go according to your wishes. Now, it still involves us going to court and telling them, give it back, but it does protect it from the full, I'll call it probate experience. So this is something that if you have had a trust done with another firm and they did not create this document, or you're not sure if it was, we're happy to review that for you as well to ensure you do have all of these facets of protection. Now, a lot of what we talk about is the financials. It's how to protect your assets, where does your money go, the nitty-gritty of money. However, the other half of what we talk about with clients often is the emotional, which a lot of times then comes down to your stuff. Where do you want your things to go? Now, for some people, they say just whoever's in my beneficiary list, they can figure it out. But I caution a lot of clients to just have that approach. And the reason is a lot of the fights, some of the worst fights that we actually see after someone passes, has to do with people's stuff. A lot of times, our clients, when they're sitting in front of us, they've been told by their kids, I don't want anything. Donate it, throw it out, I don't care. But the reality is, a lot of times, your kids are saying that because you're sitting in front of them when you're asking. The problem becomes what happens when you pass away and are no longer physically here. At that point, a lot of times your stuff becomes the embodiment of you for your kids and your family. And all of a sudden, that thing they didn't think they cared anything about has all the value in the world put on it. And unfortunately, that can mean if there's two kids, for example, who both have that reaction to a specific item, it can lead to fights that don't have a good resolution. So one of the things we've done in our trusts is put in a provision and a power that says if you do want to designate personal items to somebody specifically, using a separate letter, you can do that following the parameters that we explain in our signing appointments. So, this is something that helps not only cut a lot of those fights out, but it also carries on your legacy. Part of what we talk about is legacy. After you are gone, how do you want your legacy to look like? What do you want it to be? And the stuff, as silly for some people as it may sound, can very much shape what that legacy is for even generations to come. Is it a piece of furniture that has been in your family for generations? Is it a piece of jewelry that has a special story to it? What is it about that item that you have felt and why you have kept it that you then want to transfer down to future generations, even after you are no longer here? Again, those are things we are more than happy to talk to you about. So, again, use that free consultation if this is something that means a lot to you. Now, the other part of what I want to address in this is what pitfalls should you avoid? So, estate planning is an investment, and I mean that by it's a financial investment. A good, comprehensive, protective estate plan is not a cheap plan. Cheap plans, unfortunately, often leave a lot of holes that cause issues down the line. So I completely understand when clients come to us and ask, how can I avoid the cost? What can I do to cut costs? The problem is a lot of cost cutting options means you're cutting corners in a way that will ultimately lead to a very expensive either end of your life or your family's having to deal with the aftermath of you passing. One of the big ones is that you have the wrong type of trust. So, one of the things that we emphasize at Copenbarger is that estate planning is a life cycle. By that, I mean when you first start your estate plan, you may have needed trust A, but 20 years later, as you've gotten married, you have kids, your kids have grown up, you have grandkids, you now may need trust Z. There is a lot that can happen in that time frame to change the type of protection that you or your family needs. So we recommend you come and see us every 3 to 5 years, simply to ensure you are still protected correctly. The other issue is, do you have a trust that addresses incapacity? This is a very, very simple provision in so many ways that I have seen in way too many trusts prepared by other attorneys that is either not addressed or is not addressed adequately. What this is dealing with is what happens if you become incapacitated? You have a stroke, and overnight you can no longer make your own financial decisions, but you are in a position as trustee of your trust on all of your bank accounts. How does the next person in line, your successor trustee, prove to the bank you should no longer be the trustee and that they should step in for you? Well, we put in what is called competency determiners. This is who actually determines, are you still capable of managing your own money? If this is not addressed correctly or adequately, unfortunately, it can yet again wind you up in court and having to have the court determine you can be removed. So it is so important to ensure this is addressed correctly. So if you have a trust done by another firm, come and have us review it if you have questions. And if you have one of our trusts, but haven't seen us in the last 10 years, let's say, let's make sure that this is still up to date properly for you. Another big one that actually goes hand in hand with incapacity is Medi-Cal and veterans benefits. These are programs and benefits that come with, unfortunately, a lot of ways to be disqualified from them. And if you don't have a trust that properly protects you or your assets and doesn't allow for the right parameters around them, you can lose these benefits without even realizing you're about to do so. So, this is something that we are very passionate about. It is a much more in depth conversation. But if you have questions on either of those, again, use that free consultation. On this slide, last but not least, is not adding protective provisions that would benefit your family. So this can be you pass away first, and what happens if your spouse remarries? Do you want your half of the estate being at risk of going to a new family, or do you want it reserved for your beneficiaries? What happens if your inheritors, your beneficiaries, end up with creditor or divorce issues? They have their own creditors looking to take their money. How do you protect their inheritance? What happens if you have kids or beneficiaries that fight? This is unfortunately a stark reality, and a harsh reality, a lot of our clients do talk about. And it is that as much as they love their kids don't always see eye to eye. And what we unfortunately have found is that grief and greed can be two components that, when mixed, cause catastrophic results. So, does your trust have a contest clause in it that says, hey, if you do decide to go to court to fight my wishes, and when you lose, you then receive nothing? That is a very strict punishment, but it is a very effective punishment to make sure that, hey, you can be upset, but don't actually drag this unnecessarily into court and waste everyone's time and money. And last but not least is, do any of your beneficiaries need to be protected from themselves? Do they have some kind of substance abuse or addiction issue where you would still want them to have an inheritance, but you don't want it in their hands directly? How do you provide protection for them so that they can be protected, but still, again, have an inheritance left? These are another set of huge issues we see. Creating your own trust, amending it yourself, writing all over those documents all go hand in hand. Estate laws may seem extremely simple on the surface, but even for attorneys who don't practice this area of law, we end up having, after somebody passes away, having to clean up mistakes and messes that were made ahead of time. So this is an extremely important one. Before you start doing your own document or writing all over it or trying to make changes, call us. One of my favorite things that a CPA I spoke with said is, it is cheaper to ask ahead of time than it is to need the professional to clean it up after the fact. So come and ask us if you think it's a simple change and it doesn't need our involvement. Just ask. Some of the time we'll agree, some of the time we'll explain why that's not a good result. One of the questions I did just get is there a look back on Medi-Cal? So yes, there is. So that's one of the issues with Medi-Cal, that for some people, when they're trying to qualify, they'll just start gifting and gifting and gifting, thinking that, hey, if I deplete my money, it's not going to cause an issue. Medi-Cal, though, will look back somewhere between 3 to 5 years at what gifts you have made prior to when you're trying to qualify. So again, this is where, before you just start acting, make sure to give us a call. I mentioned that estate planning is a life cycle. So another huge one that I've already mentioned is not updating your plan as your life changes. So when you, let's say you set up your plan, you were married at the time, you're now divorced, and you're now remarried. So a lot has happened. And this is actually something we see quite often, unfortunately. Well, your trust is still in effect. So your now ex-spouse may still have control to make your medical, or financial decisions if you are no longer capable of doing so. Your new spouse may have none of those rights. So it is extremely important to make sure that your plan accounts for and identifies, how has your life changed? Do you have more kids? Have you unfortunately lost a child? Do you have grandkids now? Are they grown up? Do they need education help? How has your life changed, and how does your plan need to account for it? And then again, I already talked about this one, but not properly funding your trust, not putting assets in that needed to be before you pass away. This is, again, something that when you come in for a review, we are going to ask. Have you put your property in the trust? Have you refinanced? Have you done anything with your assets that may affect if they are still in the trust itself? Again, come and ask us if you don't know. Now, blended families are another big category that we talk about, because with blended families, a lot of times what we see is, not only are you bringing your own assets in, you may be bringing separate sets of kids in. As much as you may love your blended family, one of the things we hear is, my kids are perfect, or they're wonderful, your kids are the problem. That is one of those situations, though, that your trust can help address. You can set it up that you have a separate plan from each other to make sure your kids are properly protected. You can set it up in a way that, hey, if I die first, I want you to be able to live in the house, but ultimately this was my separate property. I want it to go to my kids. Your trust is, again, customizable to address the concerns you may or may not have with a blended family. And then last but not least in this section is making sure that your adult children are protected from outside predators. Outside predators can unfortunately rear their heads at any point. That can be that your children go through a divorce, they're in a horrendous car accident that's their fault and insurance won't cover it. They start a business and it goes under and they owe back taxes. There's a lot of things that can happen almost seemingly overnight. So, one of the things that you can put in is what is called a generation skip trust or a lifetime protective trust. These are trusts that go into effect to ensure that those outside predators cannot take your children's inheritance away. Your kids' own wealth and estate is a different conversation, but the inheritance can be insulated from, again, anyone being able to take it from them. So, this is something that you can put in place to add that extra layer of protection that would otherwise not be available without a trust. Now, for those of you that do have a Copenbarger trust, what has changed since you saw us last? So, if you have not seen us since 2020, there are a couple of changes that need to be addressed. And the first one is the Secure Act. The Secure Act is a rule that said after you pass away, especially when anyone outside of a spouse inherits, they need to now withdraw from your retirement plans within 10 years of your date of death the entire amount that they are receiving. So rather than having their required minimum distributions and then being able to take it for their lifetime and stretch it out over more years, they now have to withdraw the entire amount within 10 years. This has then again drastically changed. Not only do you need to be aware of this for your own planning, but do your kids need to then come and talk to somebody? One of the things that we have very much encouraged our clients is not only should you come and talk to us to ensure that the retirement section in your trust complies with the Secure Act, because if you have not seen us since 2020, you have an outdated retirement section that could have drastic negative effects on your kids. But the other thing we're encouraging is that you and even your children talk to a financial advisor now, because not only did the Secure Act change how they can withdraw and in what amount of time, it changed what you're able to do with retirement accounts, how long you can put money in, how much money you can put in, how much do you need to withdraw, what's the penalty for withdrawing too early or too late. So this is where it is important to not only have a qualified estate planner and estate planning attorney in your corner, but also to have a qualified financial planner. If you need a connection, if you need a referral for this, let us know. We have wonderful professionals in our wheelhouse that we refer our clients out to as needed. Now, the next one is Proposition 19. So, Proposition 19 is one that had some very profound impacts and still does on your properties and what happens when they are inherited. Now, first and foremost, there was some good that came out of Prop 19. So if you are over the age of 55 and you are looking to move within the state of California, you can now move up to 3 times in your lifetime and take your tax basis with you. So that can have huge tax savings from a property tax standpoint during the remainder of your life, if again, you're planning to move over the age of 55 in the state of California. The problem, though, is what happens after you pass away with your properties. So Prop 19 has almost completely eradicated the ability for anyone who inherits a property to keep your property taxes what you pay. And instead now a lot of times means it is going to go up to the current date of death value for, again, when you pass away. The only way for a property to keep your property tax basis after you pass is if a child inherits the property and it was a primary residence and then keeps it as their residence. So there's a few pieces. Had to be your residence, has to go from a parent to a child, and they then need to claim and own it as their residence indefinitely. If in 10 years after that happens, they decide to turn it to a rental, the taxes will go up. So what does this mean and why does it matter? Are you out of options or is there still an option available? If you have especially more than one child and you think there is an odd that they would want to own and live in your property when you are gone, this is where we are encouraging you to put in right of first refusal language. The reason for that is if the property transfers to your children and then they decide to buy each other out, whoever has been bought out, that percentage of the property tax goes up. So if you had 2 kids and they buy each other out, 50% of the taxes would still be raised to the current level. Using right of first refusal language, you allow them to do that through your estate. So on the books and distribution, everything is still 50-50, but the child who is going to take advantage of owning and living in the property gets to keep your entire basis. So that can have then huge savings every year for them for as long as they plan to own and live in that property. If you have any questions on this, there is actually a QR code on this slide that goes into more detail in some of our other education events. But of course, as I keep mentioning, you can also take advantage of the free consultation to come and talk to us about this. Now, the next piece is what happens for our seniors. So, as people get older, unfortunately, we become more and more aware of the risk of needing advanced care, but also the risk then of what is that going to cost. And so, it is extremely important to be aware of a few updates. Medi-Cal, as of January 1st of this year, changed drastically. They have actually eliminated asset restrictions. So before, with Medi-Cal, you needed to both have a need for that kind of care and financially qualify. But as of January 1st, assets are not going to be looked at going forward. With that being said, they are now looking at income. And so, depending on what your income is from retirement sources, from outside sources, you may or may not qualify at this point. So, this is very much where I encourage you to come and talk to us and then to work with a financial advisor and a CPA, even to see is there ways that you can reduce income to then qualify. The other piece is qualification is not easy. Government programs are often, again, designed to not qualify you. They have a lot of forms and a lot of things that are very easily misfilled out and then that lead to this disqualification. So we do have a team that is able to help you with those forms and actually submit that application so that it can be filled out as accurately as possible and give you the best chance of qualifying that you can have. Now, circling back to your emotional treasures, and actually, first and foremost, your digital accounts. So, cryptocurrency has become quite talked about and, frankly, very utilized by a lot of people in society. Now, a lot of our clients, they have little questions about this, but there's still not a ton of our clients that actually have cryptocurrency that they're concerned about. But it's important to note that cryptocurrency is still considered in California a personal property asset. What that means is it does not transfer how your piece of real property or how your bank accounts would transfer. It actually transfers like a piece of jewelry or your furniture. The most important thing, though, with cryptocurrency to keep in mind is you have a code, a chain, a link, some sort of identification that is the only way to access that money. So you need to make sure that you have that information and that it is in a place or given to somebody ahead of time so that they can access it after you are gone. That, though, goes into your other accounts, your emails, your social media, your cell phones, things that have passwords on them. A lot of times people don't provide those passwords, which makes sense because they want to keep their security. But I very much encourage you to have them somewhere that the person who is going to need to manage when you're gone can have access to. For example, using my grandma, when she passed away, thankfully, she had an old flip phone. She wasn't up on technology, and this was only a couple years ago. She, with that flip phone, did not have a password. And so when she passed away, we were able to go in and see her contacts and be sure to then let her friends and other family members know that she had actually passed and any arrangements that were being made. Without that, I didn't know all of my grandma's friends. I didn't know everybody that she'd ever had an impact on. And so I would not have known where to start. And so having the ability, if you do have a phone or an account with a password on it, it is important to ensure if you think that that will matter to make sure that whoever needs it will have it when you're gone. The same goes for things like cloud accounts. So where you have your photos stored, would you want somebody to have the password to access those? So again, we bring this up because it is often overlooked, but it is extremely important. But again, I mentioned that Copenbarger's trust allows you to leave personal items by a separate letter, but a lot of trusts do not. And so if you have a non-Copenbarger trust and you're writing these separate letters, but the trust does not allow that, those letters then become invalid. They're not going to be honored in a lot of cases. Now, in some circumstances, the kids all get along and they say, of course, whether it's legally required or not, we're going to make sure that mom and dad's wishes are carried out. If you don't have a family, though, that has that mindset, you again can then have the family and your estate in a boiling pot of hot water without even realizing it. So it's important, if you are utilizing these letters, to ensure that your trust actually allows you to do so. Now, I mentioned legacy. Our firm was founded by Lloyd Copenbarger because he very much believes that every person has a legacy and that those legacies matter. And protecting your legacy is worth doing the work now. The reason for that is, again, your life changes. And as much as I know everybody loves coming to talk to their attorney, it is an extremely important thing to do to ensure that you are protecting yourself, you're protecting your family, you're protecting your family as it changes, and that your assets are not going to be unnecessarily taken away by the court, by the government, by the IRS, by whatever outside predator would want to take monies that were not properly protected. So come and see us. That 3 to 5 year timeline that I mentioned is a great timeline to hold yourself to, because in general, things don't change that drastically in 3 to 5 years, but it allows us to catch things ahead of time or before it becomes an issue. But don't hesitate to come see us sooner. Again, with with these webinars and education events, you are still entitled to those consultations. So if you do need an extra consultation, come and attend one of these to make sure that you can then come and speak with us for no cost. Again, here's some additional changes to just bring up. I won't keep going into a ton of detail on them because some will apply to you and some will not, but really cannot emphasize enough. If you don't know, if you think it might apply to you, or you know it applies to you, don't delay coming to see us. Now, legacy looks different for every single person we talk to. For some people, it is your financial legacy. And so it's, how can we best protect you? Do you need a financial advisor, a CPA? Who do you need in your corner on a professional level to ensure that that financial legacy is captured? And then, do you want to leave an emotional legacy? And especially if you have questions of, how do I do this? Come and talk to us. We have clients who have come up with some really interesting and creative ways to leave their respective legacies, depending on how they want to capture them. Some are extremely simple, where it's a simple letter that was jotted out. Some people actually have all the way up to a family constitution. That is where you are literally putting your morals and values and asks in a contract that your family is going to sign off and agree to. Now, this is something that the family at one point or another may start deviating from, but it puts a lot of weight on the fact that these are the things that matter to us, and we want you to continue them for generations to come. So, as I mentioned, this was a lot of information. I hope that you found this very helpful and useful. What I definitely hope you see is either how we can help you now, or if you're all set, how we can help your family in the future. You should work with an attorney who goes through in detail what matters most to you and how can your plan capture those wants, and in a lot of cases, those needs. Your plan should be customized to you, and it should be updated to ensure, again, as your life has changed, that your plan is still protecting them properly. Now, you will see in the chat that we have put a link there. If you would take some time to just answer a few short questions about how this webinar went, we would really appreciate it. We want to ensure that this is something that is helpful for you. It is not something that we want to do if there are other pieces that we can capture and adequately address that we're not. But why should you work with Copenbarger? So Copenbarger, we have been around since 1979, and we have attorneys that take education extremely seriously. We very much believe that you should have attorneys who educate themselves so that they can in turn educate you, rather than you needing to go and do a bunch of legal research and then decide, does this actually apply or not? Your attorney should be the one doing the work and walking alongside you. We also, though, have, again, the attorneys who, from an educating themselves standpoint, have gone above and beyond. We have one of our attorneys, Sunny Boren, who is also a CPA. And many of our attorneys have gone beyond just doing the California State Bar and are actually certified specialists in this area of law. which essentially means they took a specialized focused bar in this area to prove their knowledge is far and above what many other attorneys do. After this, you will receive an automated phone call from us asking if you are interested in taking advantage of that free consultation. But if you are not quite ready to do that, we do have our team standing by at any point that you are ready to move forward. So thank you again for taking the time this morning to, taking the time this morning to listen to this webinar. I hope that it was helpful. I am going to stick around for a little bit and look at any questions that are in the chat. If there are none, we'll sign off here in a little bit. But again, if you can let us know how we did, that would be great. Thank you so much. So one of the things that one of our attendees did mention is that if you are interested in helping repeal Proposition 19, you can go to www.repealthedeathtax.com. This is something that we have talked about on prior webinars. That QR code earlier can help link you to that training that we did. This is, again, something if it is important to you and you have more questions even, definitely come and talk to us. Another question is, will this webinar be available to watch again? Yes, it will be. So these are all recorded and then put on our YouTube channel. So if you look up Copenbarger on YouTube or look up the specific title of this webinar that is on our events page at copenbarger.com, you can find this after it has been uploaded there. All right, so it looks like that is it on the questions for now. I'm going to leave our contact information up for a little bit longer. Again, if you're able to take one of those surveys for us, that would be great. Otherwise, I hope you enjoy the rest of your day, and we look forward to working with and speaking with you soon. Thank you.